Hello and welcome back. In the world of law enforcement accountability, we often speak of escalation. But what happens when a citizen remains perfectly calm, yet the situation ends in nearly lethal gunfire? Today, we are dissecting the Minneapolis incident involving an ICE agent and Renee Nicole Good. This isn't just a shooting. It is a complex legal puzzle involving plainclothes operations, the Tennessee versus Garner fleeing felon rule, and the inevitable, massive federal lawsuit that will follow. Let's analyze the footage. To understand the gravity of this situation, we must first examine the totality of the circumstances. The footage begins not with a high-speed chase, but with a static confrontation. Notice the attire of the agents. We see heavy flannel, beanies, and tactical vests that are not immediately distinguishable as law enforcement to a layperson. In the United States jurisprudence, the reasonable person standard is paramount. Would a reasonable person, in Renee Good's position, immediately recognize these individuals as federal agents executing a lawful warrant, or as armed assailants? The dialogue here is critical. The subject exhibits a demeanor that psychologists might classify as detached or compliant defiant. She states, "I'm not mad at you, and that's fine, dude." This audiovisual dissonance is striking. Usually, in use-of-force incidents, we observe shouting matches and chaotic energy. Here, the citizen is de-escalating verbally while the agents are escalating tactically. Legally, we must look at the Fourth Amendment, which protects against unreasonable seizures. For a seizure to be lawful, the display of authority must be clear. When agents operate in plain clothes, the burden of identification is higher. The subject's confusion, asking them to show your face, suggests she may not fully grasp the legitimacy of the stop. This ambiguity is the seed of the catastrophe that follows. If the citizen genuinely believes she is being carjacked or harassed by non-officers, her attempt to retreat changes from evading arrest to self-preservation in the eyes of a jury. The failure of the agents to establish unequivocal command presence without resorting to immediate aggression creates a tactical vacuum, one that was filled, tragically, with lead. Wait, stop for a moment. If this officer found cash in your pocket right now, could you legally stop him from seizing it? Civil asset forfeiture allows police to take your savings without even charging you with a crime, and hiring a lawyer to fight it costs over $300 an hour. That is why I created the Anti-Seizure Cash Protection System. It is a complete legal toolkit containing the exact scripts and packaging protocols you need to bulletproof your assets against seizure. For just $27, which is less than 10 minutes of a lawyer's time, you can protect your hard-earned money from legalized highway robbery. Get your copy of the Anti-Seizure Cash Protection System at the link below. And now, enjoy the rest of the video.
It'll be the same plate when you come talk to us later. That's fine. U.S. citizen, former fucking veteran. You want to come at us? You want to come at us? I say go get yourself some lunch.
Now, we transition to the critical moment of force. As the vehicle begins to mobilize, observe the positioning of the primary agent. In modern policing tactics, stepping into the path of a fleeing vehicle is universally condemned. It creates a self-imposed jeopardy. The agent places himself in a position of danger, which he then uses as the justification for lethal force. Under the Supreme Court precedent of Graham versus Connor, use of force must be objectively reasonable. Furthermore, Tennessee versus Garner prohibits the use of deadly force against a fleeing suspect unless that suspect poses a significant threat of death or serious physical injury to the officer or others. The question the Department of Justice will ask is, did this slow-moving Honda Pilot pose an imminent threat? The video evidence is damning. The vehicle was turning away from the agents. The shot was fired as the car was already on an egress trajectory. This suggests the force was not used to stop a threat, but perhaps punitive in nature, an attempt to stop the flight itself. In federal court, contempt of cop is not a justification for discharging a firearm. The agent's decision to fire into a moving vehicle in a residential neighborhood also demonstrates a reckless disregard for public safety. A stray bullet could have easily entered a home. This segment of the encounter moves the needle from a procedural error to potential criminal culpability. The agent's reaction, immediate lethal force against a non-violent, albeit non-compliant, subject, will be the centerpiece of the criminal investigation. Finally, we must address the inevitable aftermath, the litigation. This incident is a textbook example for a high-stakes civil rights lawsuit. Since the shooter is a federal agent, likely ICE or US Marshals, the legal avenue is slightly different from suing a local police officer. We are looking at a Bivens action or a claim under the Federal Tort Claims Act, FTCA. The victim's legal team will undoubtedly file for compensatory damages to cover medical bills, which for a gunshot wound and subsequent rehabilitation will be astronomical. But the real financial exposure for the government lies in punitive damages. These are awarded to punish egregious conduct and deter future violations. Given the video evidence, a settlement in the mid to high seven figures is not a speculative estimation. It is a probability. The defense will almost certainly invoke qualified immunity, a doctrine that shields government officials from liability unless they violated a clearly established statutory or constitutional right. However, the precedent regarding shooting into moving vehicles is becoming increasingly unfavorable for law enforcement. If the court determines that the agent created the danger by stepping in front of the car, or that the car was driving away and posed no threat, qualified immunity could be pierced. Furthermore, the municipality and the federal agency could face Monell claims. Though technically for local gov, similar principles apply regarding policy and training failure. If it can be proven that this task force had a pattern or practice of reckless conduct, the liability expands significantly. We are looking at a potential payout that burdens the taxpayers. Beyond the civil torts, there is the career destruction of the agent involved. An internal affairs investigation will likely conclude that the use of force was outside of policy. We have seen similar cases, such as the shooting of Ashley Babbitt or various vehicle-related incidents, result in years of litigation. But here, the video is the star witness. It provides an unfiltered account that contradicts any potential police report claiming the agent was pinned or run over. In the coming months, expect to see motions for summary judgment, intense depositions, and a battle of expert witnesses dissecting every frame of this video. For the agency, this is a public relations nightmare and a financial liability. For Renee Good, it is a life-altering trauma that will likely result in a substantial transfer of wealth from the federal government to her trust account. Justice in the American system often comes in the form of a check, but it rarely undoes the damage of the bullet.